Good morning. Can you get roll call, please?
Commissioner Payne? Commissioner Butch?
Here.
Commissioner Deskovich? Commissioner Figurs?
Here.
Commissioner Fusak?
Here.
Commissioner Lyles? Commissioner Lucas? Here. Commissioner Stewart?
Here.
We have a quorum present.
Thank you. Stand for the Pledge of Allegiance, please. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Good morning. I have some preliminary announcements to make. It's the long mic, right? Yes. The First District Court of Appeals graciously lets us use their facility, so please respect their rules and have absolutely no food or beverage other than water in this room. And please silence your cell phones. We have received some feedback from the public that sometimes it is difficult to hear the members and those before the commission, both in the room as well as over live stream. Anyone addressing the commission, please make sure to speak up and speak into the long microphone at the podium. That way you can be heard, so our broadcast and audio recording equipment can pick it up. To any fellow commission members, please speak up into the long microphones on the dais so your comments and debate can be heard. If you share your microphone with another member, I can skip that one today. I also ask you to be brief and concise as possible in your questions and comments, as we have a number of items for consideration today. Pursuant to Section 286.0114, the Florida statutes, members of the public have an opportunity to have input on matters before the commission other than in cases in which we act as a quasi-judicial capacity. The means of the public can have input on matters other than complaints, opinions, and determinations on financial disclosure cases. If you desire to be heard on the matter, please fill out a speaker card and give it to Ms. Fulford, who has her hand up in the back. Thank you. Okay, the first item for consideration, and just want to know if I can take the two items, that would be items 3 and 4 under one motion. No. That would be item 3 would be public video conference meeting minutes of November 26th, as well as the minutes for the Friday, December 6th meeting. Can I get a motion to approve those 2 minutes?
Moved. Second.
Any opposition? Hearing none, motion passes unanimously. Thank you. Our first item is going to be item 5, consideration of final action and joint stipulation. The first 4 items in our consideration today relate to complaints where probable cause was found in a previous meeting of the commission. And we now have before us a proposed joint stipulation between commission advocate and the respondent. After considering all the materials and the presentations of the parties, the commission may vote to approve or reject the stipulation. If a stipulation is rejected, the parties cannot renegotiate and present a new stipulation at this meeting. The complaint would go to the Division of Administrative Hearings for an evidentiary hearing, or the parties could negotiate a new settlement for consideration at another commission meeting. Senate Bill 7014 passed in 2024. Contained changes to the requirements related to the commission's consideration of stipulations. I'll recognize our General Counsel, Steve Sikowski, to explain the new law. Good morning, Steve.
Good morning, Mr. Chair, and thank you. Commissioners, as you may already know, respondents and advocates can reach a stipulated agreement to resolve a complaint that has been investigated by the commission. Usually, this happens after a probable cause finding has been made, but sometimes it happens before probable cause has been found. In either event, these proposed stipulated agreements are presented to the commission for approval. The commission's authority for approving and rejecting stipulated agreements was the subject of a statutory change last year. For various reasons, some time has passed since the commission was last presented with a stipulated agreement, and we've had some new commissioners appointed in the meantime. For those reasons, I thought it might be helpful to go over the change in the law before you consider the stipulated agreements before you on today's agenda. Prior to the change in the law, the Code of Ethics granted the Commission authority to, quote, enter into such stipulations and settlements as it finds to be just and in the best interest of the state. Thus, the Commission was required to review the matter at hand and find that it was in the best interest of the state to enter into the agreement, and the Commission was effectively charged with not entering into any settlement that, in its collective judgment, was not in the best interest of the state. Like anyone who is being offered a contractual agreement, the Commission had three choices when it considered a stipulation. It could entertain a motion to approve the stipulation, which would be an acceptance of the terms of the stipulated agreement, and that motion would pass with a simple majority of the present members. It could entertain a motion to reject that stipulation, which would mean declining the terms of the agreement and foreclosing for future consideration of that particular proposal, and that motion would pass with a simple majority of the present members. Or it could entertain a motion to table the matter for the following meeting, which would be a decision not to accept or reject the terms, but to delay making a decision. Usually, that would happen only if the votes to accept and reject had tied and further discussion could not resolve the tie. The recent change in the law now requires that any vote to reject the proposed stipulation must be supported by two-thirds of the members present two-thirds of the members present to pass. With that change, much of the task of reviewing these proposed stipulated agreements remains the same. You will still need to evaluate the stipulation to make a finding that it is in the best interest of the state to approve it. Because the law requires that you make such a finding before entering into a stipulated agreement, a successful vote to approve is still necessary. And if you are entertaining a motion to approve the stipulated agreement, it still requires a simple majority to pass. That part of the law did not change. However, if you are entertaining a motion to reject the stipulation, essentially to decline the proposed agreement, that motion cannot pass unless two-thirds of the members present for the meeting have voted in support of that motion. Thus, it is possible to arrive at a scenario where the Commission does not have enough votes to approve a stipulation and also does not have enough votes to reject the stipulation. For example, if 7 commissioners were seated but only 3 voted in favor to approve for a motion to approve, that motion would fail because the majority did not vote in favor of it. If those commissioners then entertain a motion to reject that stipulation and the other 4 commissioners vote in favor of that motion, we will have a majority, but will fall short of the required two-thirds required to reject the stipulation and decline the proposed agreement. In cases like that, the stipulation will not be approved, but it also will not be rejected either, meaning it will be tabled for consideration at the following meeting. The change in law did not create any requirement that you adopt a stipulation if you cannot reject it, and it did not make adoption of those stipulations automatic if you fail to reject. Like I said before, you still have to find that entering into the agreement is in the best interest of the state, and that finding can only be made affirmatively by approving the stipulation. That is my presentation on the change of the law and how it affects stipulated agreements, and I'm available to answer any questions you may have, either now or at any time during the meeting. If there's no questions for me, then we can allow the advocates to present today's stipulations.
Thank you. Does anybody have questions? Thank you, Steve.
Thank you.
Okay, the first stipulation is going to be 22-041 and complaint number 22-115. They're consolidated. In re Gregory Tony. Complainants have the right to respond in writing to proposed stipulations. We did receive a response from the complainant, and it was included in the meeting materials in this case. Are there any members of the commission who need to make a disclosure regarding this case? If so, please state that for the record at this time. Seeing none, Ms. Hadley, you are recognized, and you may proceed.
Thank you. The Respondents' Council is present.
Stephen Webster, Sheriff County.
Okay. Respondent currently serves as the Broward County Sheriff. He was appointed to the position on January 11th, 2019, and has subsequently been reelected. The Criminal Justice Standards and Training Commission, which I refer to as the Standards Commission, has jurisdiction over respondents' law enforcement certification. After a complaint was filed with the governor's office, the Florida Department of Law Enforcement investigated approximately 4 matters that were eventually referred to the Commission on Ethics after the state attorney's office in the 20th Judicial Circuit declined to prosecute. The matter was referred to the Commission on Ethics, where the Commission on Ethics found probable cause to believe that respondent misused his position regarding 4 sub-allegations. 1 was during the hiring process for employment with the police department. 1 was during the appointment of his service as the Broward County Sheriff. The other was regarding a Standards Commission form, whether there was a false information on it, and also the last lead regarding whether there was false information while renewing his driver's license. At the same time, the commission found probable cause. The Standards Commission and FDLE filed an administrative complaint with the Division of Administrative Hearings against respondent. The FDLE prosecution team chose not to pursue certain matters after the investigation by FDLE. FDLE could have pursued all of the allegations, but it did not. It did not pursue the Form 68 allegation because of a lack of evidence, and that's the Standard Commission's form. There was no evidence that respondent lied on the application regarding his appointment for sheriff because there was no application. In addition, respondent was not a public employee or official when he applied for those officer positions. FDLE did pursue the driver's license issue at DOA. It initially pursued 8 counts of the driver's license allegations. However, prior to the hearing, FDLE dismissed 3 counts due to respondent not being a certified law enforcement officer in Florida when the allegations occurred, which left 5 counts. Ultimately, only 1 count was found to be in violation, which brings us here. The Standards Commission is in charge of respondent's law enforcement certification and only pursued 1 matter. And then it was only able to prove 1 sub-allegation, and that was the driver's license issue that occurred in February 2019. The Standards Commission penalty was a letter of counseling. In the matter before you, respondent has stipulated to the same solo allegation that FDLE was able to prove at a full hearing before DOA. Sheriff Toney has stipulated to receiving a public censure and reprimand to resolve this allegation, which is consistent with what occurred in the same matter with the Standards Commission. We respectfully ask for the commission to approve this joint stipulation.
Thank you very much. Any comments, questions? Yes, go ahead.
Yes, let me ask you a question. Do you think that this is a strong case to take to the ethics hearing? You think this case?
So the same matter has already gone to the Division of Administrative Hearing regarding the driver's license. FDLE, which is another state agency, was only able to prove 1 of those, and that's the one we have here that the respondent, Sheriff Toney, has stipulated to. Regarding the other matters, no, and I explained it in my presentation why I think not.
Mr. Chair?
Yes, go ahead,
Do
proceed.
you think it should be settled?
Yes, sir. And I believe that is consistent with what the other agency that is in charge of his law enforcement certification in the same manner, and it's consistent with that.
Just really quick, I understand that your recommendation was prior, no probable cause,
Yes, sir.
and the commission found probable cause.
Yes, sir.
So given that, that step, you think that the settlement is in the best interest of the state?
So when the commission found probable cause, that was just a probable cause to believe there was a violation, and that was only based on a preliminary investigation. Subsequent to that, there's been a hearing on some of the same matters that have been resolved at the same place, Division of Administrative Hearings, where this case would go. So I do believe it would be in the best interest in that it's consistent with what has already occurred after a full hearing.
Oh, I understand completely. Any other comments? Is there a motion? Okay, thank you. I apologize. Respondents?
Good morning. Stephen Webster here on behalf of Sheriff Toney. You know, As soon as Sheriff Tony was appointed by Governor DeSantis, his detractors have been coming after him nonstop, relentlessly. The state has literally wasted thousands and thousands of dollars investigating every aspect of his life, going all the way back to when he was a juvenile, for a matter that he was exonerated of by a trial court judge. They have literally turned over every stone. They brought every sling and arrow they could against the man. And in spite of that, he has led the third largest sheriff's office in the United States of America with absolute dignity and integrity. He got 70% of the vote in the last election. It's the largest margin of victory ever in Broward County for a sheriff. He has endured years and years of this. We came here, and I believe Ms. Hadley was correct in recommending no probable cause the first 2 times. And it takes courage and integrity for an attorney to stand up and make that pronouncement. But there was no evidence that Sheriff Tony used his office for any sort of corrupt purpose. None. Nonetheless, the commission found probable cause, and we all agreed that we were going to go to DOA with FDLE because they had the strongest evidence if anybody did. Now, the hearing officer sustained that one finding that Sheriff Tony did not tell the driver's license examiner about a suspended license in 2019. But there's a case directly on point from the 2nd DCA where that court said that a violation of probation could not be founded upon a driver's license examiner's testimony regarding that same exact issue. In that instance, the 2nd DCA said that because the driver's license examiner could have made a mistake in entering the data, it couldn't even make a preponderance of the evidence finding based upon that. So the commission, CJSDC, ended up recommending the letter of counseling to Sheriff Tony. So we didn't appeal it because of that. And we're here today basically with that same one count that can go forward in good faith at all. I'm not trying to cast aspersions, but FDLE, the investigator, didn't even know that 5 of the 8 counts that he had brought against Sheriff Tony for allegedly not checking a box, he had made those applications online, and the question's not even asked. They found that out at the hearing. They learned for the first time. Enough is enough. Sheriff Tony needs to lead Broward County and the sheriff's office there, and his detractors, the people who didn't agree with his appointment, need to live with it and deal with it. We're not supposed to use these commissions for political axe grinding, and that's what's happened here. I would ask that this commission adopt this recommendation. It's consistent with what the Division of Administrative Hearings ultimately determined and with what CJSTC adopted. Thank you for your time.
Thank you. Is there a motion on the floor? Does anybody like to make a motion to accept or
Motion to adopt the proposed joint stipulation.
a second?
I'll second.
Okay. Any opposition? Let's take a vote on this.
Yes.
No. No.
Yes.
Yes.
Thank you. Thank you.
So I had previously spoken with the executive director. I have to run out for a hearing that has not been
They did
continued.
not give you a continuance.
I'll be right back. My apologies. I couldn't get it continued beforehand. Goodbye.
Let's move the items around a little bit. Let's move on to item number 7, consideration of advisory opinions. The next agenda item is a consideration of advisory opinion file 2816. Any public officer, candidate for public office, or public employee in Florida who is in doubt about the applicability of disclosure laws or standards of conduct to himself or herself or anyone who has the power to hire or terminate another public employee may seek advisory opinions from the commission about himself, herself, or that employee. Advisory opinions are based solely on the facts provided by the requester and are legally binding on the conduct at issue. Is the requester in attendance?
I do not believe so, no.
Okay. Ms. Stephanie Novenario?
Hello.
Close enough, right? And I practiced it too.
Thank you. I'm Stephanie Novenario.
Novenario.
I am the newest attorney with the Commission on Ethics. Thomas Moss, the city attorney, if I may.
Yes, you may proceed, sorry.
Thomas Moss, the city attorney for the city of Sunrise, submitted this request for a formal opinion on behalf of Sunrise City Commissioner LaToya Clark. Commissioner Clark wears two hats. She is a Sunrise City Commissioner, and she also serves as the president of the East Sunrise Residents Association, Incorporated, ESRA. ESRA is a nonprofit organization with goals of beautifying, informing, and improving the conditions of the neighborhood. Commissioner Clark wonders whether her continuing to serve, both as a commissioner and as the president of ESRA, would result in a prohibited conflict of interest. The issue presented in this request is not a new or novel issue for the Commission. Clear past precedent guides our analysis of this question, and this question could have been handled at the staff level. However, because Mr. Moss and Commissioner Clark specifically asked for a formal opinion, we have proceeded with a formal opinion as requested. The applicable portions of the Ethics Code are sections 112.313(7)A and 112.313 sub 3. Section 112.313(7)A contains two prohibitions. The first prohibits a public officer from having any contractual relationship or employment with a business entity or agency that is regulated by or doing business with his or her agency. The second portion of Section 112.313 sub 7A prohibits a public officer from having a contractual relationship or employment that will create a continuing or frequently recurring conflict of interest or an impediment to the full and faithful discharge of her public duties. Both prohibitions require the public officer to either be employed by or to have a contractual relationship with a business entity or agency. Here, Commissioner Clark has no employment or contractual relationship with ESRA. The Commission has held that to be employed, a person must receive compensation or some form of consideration. Here, Mr. Moss indicates Commissioner Clark is unpaid in her role as the president of ESRA, so she is not employed. As for whether she has a contractual relationship with ESRA, we have held in the past that public officers' rank and file membership in a nonprofit organization creates a contractual relationship between the public officer and the nonprofit organization. However, here, the facts provided by Mr. Moss indicate that ESRA has neither a formal structure nor a defined membership. Meetings are open to anybody in the community, and there are no fees, dues, or charges for attendance. Mr. Moss also indicates that Commissioner Clark has no formal agreement or contract with ESRA that actually establishes her presidency. Without employment by ESRA or a contract with ESRA, Commissioner Clark does not appear to have a prohibited conflict of interest pursuant to either prohibition in Section 112.313(7)A. The second applicable section, Section 112.313 subsection 3, also contains two provisions. It forbids a public officer from purchasing, renting, or leasing realty goods or services for her agency from a business entity of which she or her spouse or her child is an officer, partner, director, proprietor, or the owner of more than 5% interest in the business entity. It also forbids a public officer or employee acting on behalf of their business entity to sell, rent, or lease realty goods or services to her own agency or any agency of her political subdivision. In this case, neither prohibition applies because the facts do not indicate any purchasing, renting, leasing, or selling of any realty goods or services between the city and ESRA. Therefore, we recommend the Commission find that Commissioner Clark's simultaneous service as both a commissioner and the president of ESRA presents no current prohibited conflict. I'm happy to answer any questions you might have.
Thank you very much. Any questions from the members? Yes.
Thank you very much. I noticed that there was an opportunity for Christmas gifts given by the police department that had no connection with the commissioner. But my question is this: is there any time that the commissioner has requested other items on behalf of the commission for this organization?
Through the chair. The facts did not indicate that she had done that. Every fact that was indicated by Mr. Moss was put into the opinion, so that what you've seen is what the commission has received. There is the possibility that if Commissioner Clark attempts to lobby or request or solicit these donations and things of that nature, then she could be violating certain subsections, such as 112.313 subsection 6, which is the misuse of her public position, and the similar constitutional prohibition against a disproportionate benefit. We have included a short paragraph in the draft opinion that does warn Commissioner Clark about those two subsections and also subsection 8. I did not yet include one about the gift prohibition, but I could also include a few sentences along that line as well, just to inform her that in the future she needs to be aware of these things, and should anything like that arise, she should reach out to the commission.
Any other questions? Thank you. And you said the requester was not here, correct? They're not present.
Correct, not here.
Can I get a motion to adopt of the draft opinion?
Move.
Can I ask a question? Is it the draft opinion as written or with the modification suggested by Commissioner?
Yeah. We're going to do it with the modification?
Sure.
Okay, second.
Okay,
If it wasn't
thank you.
already.
Good idea.
All in favor, say aye. Say yes.
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 And hearing no oppositions, the motion passes unanimously with the adoption. Thank you. Okay, we're going to be moving on to item number 8, which is a consideration of financial disclosure appeals. FD 22-020, in re Hugo Martin Rodriguez. This is a consideration of an appeal of the automatic fine assessed for the failure of Mr. Martinez Rodriguez to timely file the annual financial disclosure form. Is the appellant or their counsel in attendance? If so, please state your name for the record.
No.
Are there any members who want to, or need to make a disclosure on this case? Seeing none? All right, Ms. Novanario, I'm going to get this right. You can present the draft order.
Thank you, Chair.
Thank you.
Mr. Hugo Martin Rodriguez is the appellant in this case. He, at the time of when he was supposed to file the financial disclosure, was an employee with the statewide Guardian Ad Litem program in St. Petersburg. He failed to submit a form year 2021 Form 1, and that resulted in a fine of $1,500, which is the maximum fine. He did eventually submit a form on December 1st, 2023, 456 days late. As his reason for appealing the automatic fine that was assessed, appellant noted a lack of notice. He denied that the signature on the return receipt from July of 2022 was actually his signature. He also noted an assessment of the fine would be devastating to his financial circumstances. We recommend that the fine be waived because there is no evidence that appellant actually did receive the notice that was sent to him. If you have any questions, I'm happy to answer them.
Are there any questions?
Not me.
Oh, go ahead.
Sorry.
No, go ahead, Commissioner Stewart, go ahead.
So you were, the object of verifying the signature was not pursued?
No, there is a signature that is on the return receipt, but our decisions have to be made with competent substantial evidence. And so far, the only evidence that we have is the fact that there is some sort of signature on the return receipt, but also a statement of the appellant stating that is not his signature. So there has been no attempt to determine whose signature it actually is, other than the statement made by appellant that states it is not his.
Okay.
Any further questions? Can I get a motion on the final order, to adopt the final order?
Motion to adopt the final.
Second.
Second? Thank you. All in favor, say yes.
Yes.
Yes? All right, motion passes. Thank you very much. The next item is going to be no hearings, correct?
Yes.
It's going to be on the same item, item 8B. Now we turn to the appeals of automatic fines for failure to timely file their annual financial disclosure form, where no hearing was requested by the appellant. Because none of the listed appellants requested to be heard, there will be no oral presentation on the content of these appeals unless the member requested. Are there any other appeals a member wants to set aside for presentation or staff or to disclose a member needs to put on the record? Seeing none, are there any questions for the members for these appeals? Seeing none either. Would anybody want the staff to present any of the matters before them? Can I get a motion for the entire group? This is going to be 8B, 1 through 8, for the adoption of the order.
Motion to adopt the final orders for item 8B, 1 through 8.
First and a second. Any opposition? All in favor, say yes.
Yes.
Motion passes unanimously. Thank you very much. Moving on to the annual report. It's going to be item 9. Item 9 is the Commission's annual report for the 2024 calendar year. Once adopted, this report will be provided to the House and the Senate and will be published on the Commission's website. You may proceed, Ms. Director.
Thank you, Mr. Chair. Commissioners, this annual report was in your materials for the January meeting, which we were unable to have, as well as this meeting. We're very proud of the work of the Commission. We appreciate the hard work that Lynn on staff has put in putting this report together. I'm happy to answer any questions that you might have. I will note we do have a chart in there on investigative timeframes, which was a matter of discussion last year and ultimately a matter relating to passage of legislation. And the 150-day timeframe was not applicable for the majority of the 2024 calendar year. That did not become law until October 1st. Nevertheless, about 76% of our investigations that were completed in 2024, and that's across all years, were completed within that time frame. Other than that, I'll be happy to answer any of your questions. And that completes my presentation. So we'll just need an adoption.
Yes. And can I get a motion to adopt the 2024 annual report?
So moved.
A motion, second?
Second.
Stewart, giving a second, thank you very much, with the nod.
Say
Any opposition?
loudly.
Hearing none, all in favor, say yes.
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 Passes unanimously, thank you very much. Discussion, item number 10.
Mr. Chair,
Yes,
I know we do have
okay.
if it's going to be had, so maybe we move to the expenditure of the cost.
All right, let's table that for right now, and move on. Move on to item 11, thank you very much for that. That's going to be consideration of approval for expenditure for e-filing call center. This morning, we have before us the consideration of the expenditure for the electronic filing call center. This is not a quasi-judicial proceeding, so there will be no opportunity for the public comment prior to the commission's vote. After issuing the RFP, the highest scoring vendor was ROICX. I'll recognize Carrie to summarize the commission's process in the selection of the call center vendor and the proposed expenditure. Thank you, Carrie.
Thank you, Mr. Chair. Commissioners, in your supplemental materials and loaded on your database this morning was a memorandum that I put before you seeking your approval to make an expenditure for the call center. And there's detailed background in that memo. But to highlight a few things this morning, the commission needs additional staffing and flexibility with staffing levels to meet the demand for filer support during disclosure season. This is filer support for the Form 1 Statement of Financial Interests. We require a company that can provide excellent customer service, phone support with the ability to scale up and scale down quickly in relation to the demand that we're seeing. This summer will be our second, disclosure season with both Form 1 and Form 6 filers filing electronically. Last year, we utilized a call center to assist us with customer service for Form 1 filers, and we used a process where we did a request for information followed by a request for quote. Notwithstanding that we were pleased with the service provided to us by Alight last year, given the fact that last year we went into the season not having any statistics or call metrics about what we might face, now that we have a year under our belt and we were armed with statistics, we worked with the Office of Legislative Services, including the OLS General Counsel Kyle Gray and Teresa Dollar in our purchasing office, to put together an RFP. The technical evaluation was conducted by 3 members of staff. It included an evaluation with points awarded for qualifications, experience, and the solution offered by the vendors, as well as vendor presentations and vendor references. The cost proposal was scored by the Office of Legislative Services Purchasing Office based on the equation in the RFP. Once we scored the technical proposal and provided those scores to the Office of Legislative Services, they added together the technical scores with the cost scores to determine the winning vendor. Commission staff did not know the costs when the technical scores were evaluated. ROI-CX received the highest overall score. They had the highest technical score, and they had the lowest cost. The proposed cost comes in at $262,416. This is significantly less than last year's. I think it just comes in under $225,000 less than last year's call center. We are under a shorter duration this year for the call center. We are starting it later and likely ending it early based on the demand that we saw. The reason that we did not exercise the renewal available in the contract from last year was to make sure that we had the best possible customer service solution at the best possible value for the taxpayers. I believe we have accomplished that goal, and I respectfully request your authorization for us to enter into those final contract negotiations, execute a contract with them for this amount. The funds would come from the Commission's carry-forward dollars as anticipated in our budget request. And that completes my presentation. I'm happy to answer questions, but would ask your approval.
I don't have any questions. Any members have any questions to Carrie? No. Oh, go ahead.
Is it just, so there was discussion last year about the price tag, and I think there was a little bit of nervousness, so the drop by 50% is outstanding. Is it just the slightly more limited duration that accounts for the drop in cost, or is there something else you can attribute that to?
Through the chair. The amount being charged by the vendor, the hourly rate is less, and they have waived some of their fees as well in the cost. So it did come in at a lower rate.
Thank you.
And on the heels of that, thank you. I just have a question on page 3 of the report that's before us. I see that Strata came in actually third, but ROI Solutions, their cost is higher, but yet their overall cost is I'm just wondering the scores. I mean, the scores, they clearly, on the technical scores, they outperformed everybody else. I'm just wondering what denotes that
Yeah.
cost.
The cost score is the total amount of points awarded, I believe, was 120. So they had 108 out of 120.
Okay.
in terms
I see,
of
so
their
that's not really cost, that's the score. Go ahead, Steve, I'm sorry.
I mean, just to jump in, because I think Carrie might not be understanding what you're asking. The way that we did the cost was the lowest cost got the highest score.
Yes.
So that what
Yeah.
you're seeing there where it says cost and the highest number there, that reflects that they had the lowest score. The other scores are proportional to that lowest score.
Thank you for the clarification,
Right,
Steve.
thanks for confusing us, thank you, Steve, that's great. So the lowest number got the highest number. All right,
Lowest cost, highest score, yes.
was trying to make it confusing, but yeah, I understand. Thank you, Steve, thank you. All right, can I get a motion to?
Well, could I?
Oh, I'm sorry, go ahead. Sorry.
Thank you. I'm usually not that quiet. So this is not for a full year that you're requesting this amount. Is that correct? It's not a full year, it's,
Correct. This is what we would call a seasonal call center, so we don't require additional backup except for during disclosure season, which will run from May, usually through the end of August, which is the peak of disclosure season. I think last year in June alone, we had 10,000 incoming calls to our office.
they follow up? So this would be the same price for next year?
There is likely to be in the contract, in the base contract we included with the RFP, would include a renewal option where we could negotiate a renewal next year.
Thank you. Any further questions, comments? All right, can I get a motion to approve the spending authorization for the e-filing call center, RFP 950?
So moved.
Second?
Second.
All in favor, say yes. Yes. All right, motion passes unanimously. We're going to move on to item 12. And I'm sure the executive director has your report.
She's uncovering it as we speak. Okay. As for the executive director report, I don't have anything to add to my written report except that I would like to ask Steve to give you an update on litigation.
Thank you, Steve.
Thank you, Mr. Chair. I wanted to provide you all an important update on two cases in your litigation report. In both of these cases, updates have occurred since the litigation report was mailed to you as part of the mail-out for this meeting. A little more than a week ago, the First District Court of Appeal rendered its opinion in the matter of Douglas Underhill versus the Commission on Ethics. Opposing counsel on that was Mark Herron. He is here today. One of the commissioners asked that I provide an update about this opinion today. This matter has been in your litigation report for well over a year. Douglas Underhill, as those reports would tell you, Douglas Underhill was a county commissioner for Escambia County. After the commission found probable cause in his case, an ethics hearing was held at the Division of Administrative Hearings. The ALJ issued a recommended order finding that Mr. Underhill violated 3 provisions of the gift law, and for those violations, the ALJ recommended the imposition of a public censure and reprimand and a civil penalty of $5,000. The ALJ found no clear and convincing evidence that Mr. Underhill violated sections 112.313 subsection 6, the misuse statute, or section 112.313 subsection 8, which prohibits certain disclosures, or that he committed 2 more violations of the gift law. The commission then considered that recommended order from the ALJ at its final hearing. At that hearing, the commission adopted the recommended order of the ALJ with 3 significant changes, all of which were the subject of the appeal at the first DCA. First, the commission found that the ALJ's conclusion that Mr. Underhill did not violate section 112.313 subsection 8 was not as reasonable as the ALJ had concluded, and they found that he had violated that law instead. As a reminder, section 112.313 subsection 8 prohibits a public officer or employee from disclosing information not available to the public where that information was acquired through means of their public position and that was used for the benefit of themselves or someone else. The commission found that Mr. Underhill violated this provision when he disclosed shade meeting transcripts concerning litigation to a public records requester named Mr. Evans over the objections of the county attorney who had advised him that the transcripts were confidential. The commission reasoned that the transcripts had been disclosed to Mr. Evans and their mere disclosure to Evans, who was not otherwise entitled to them, was also the prohibited benefit. But the court held in its opinion that the benefit must derive from the disclosure and the disclosure alone cannot constitute the benefit, the prohibited benefit. Second, the commission found a fourth violation of the gifts law against Mr. Underhill. Mr. Underhill had posted a GoFundMe to solicit and accept donations to a legal defense fund. The ALJ found that the prohibition against soliciting gifts from vendors and lobbyists in the gift law did not violate, The ALJ found that the prohibition against soliciting gifts from vendors and lobbyists in the gift law did not prohibit him from making a general solicitation for donations on his GoFundMe page. The proposed final order prepared by the commission legal staff agreed with the ALJ. In that document, your legal staff posited that the gift law prohibited personal solicitations rather than general solicitations of vendors and lobbyists and recommended no violation be found. The commission, however, disagreed and voted instead to find that it was more reasonable that general solicitations were prohibited. Since then, you've seen some formal opinions that reference this finding, and each time we've cited to the final order in the Underhill case. The court disagreed with the commission and found that the solicitation ban prohibited public officers and public employees from soliciting gifts from vendors and lobbyists specifically, and that general or passive solicitations were not prohibited by the Code of Ethics. Third, the commission voted to increase the civil penalty from $5,000 to $35,000. The Administrative Procedure Act provides a legal standard for increasing penalties recommended by an ALJ, requiring that the agency review the entire record and state with particularity its reasons for increasing the penalty by citing to the record to justify the action. The court recognized the commission's legal staff had provided the proper guidance, writing in the opinion, quote, despite repeated reminders from its staff counsel of the requirements, the commission failed or refused to address separately and particularly the penalty for each violation and specific reasons with reference to the record for increasing it. Essentially, the court wrote in its opinion that the commission started with the idea that it would assess a $35,000 penalty and work backwards to increase the civil penalties of the individual violations, pointing to the cumulative severity of those violations instead, rather than the reasons unique to each violation for increasing the individual penalties. The court concluded its opinion by finding the commission had abused its authority at the final hearing. It set aside the commission's final order in the matter and remanded the case to the commission with directions to adopt the ALJ's recommended order in toto as the new final order instead. We expect to present you with that final order that will comport with the directions of the court at our next commission meeting in April. The second case that I wanted to provide you a quick update on, because there have been some developments since the mailing of the litigation report. We have the case in the 11th Circuit Court of Appeals, Garcia versus Stillman. This is federal litigation concerning the in-office lobbying ban found in Article 2, Section 8F2 of the Florida Constitution. As you might recall, the in-office lobbying ban prohibits certain public officers from lobbying for compensation on issues of policy, appropriation, or procurement before federal, state, and local government agencies. This law was challenged on free speech grounds, and the district court had ruled against us enjoining the commission from enforcing the ban. We appealed to the 11th Circuit, and the 11th Circuit issued a stay of that injunction to all public officers except the named plaintiff, Rene Garcia. Oral arguments just occurred on February 26th, so a little more than a week ago. We were represented by Allison Preston, Deputy Solicitor General of the Solicitor General's Office. Audio is available of the argument. The argument altogether was about 43 minutes, and the judges seemed very receptive to our arguments, but it would be impossible to predict what will happen next, of course. We expect a ruling on that appeal soon. So those are the updates on litigation that I wanted to present you. Thank you.
Thank you, Steve. Any comments, questions?
I have one question. Sorry.
No, you're good.
The Underhill appeal, I see that the first district has it's a 22 case number. What year was the final order that was the subject of that appeal?
The final order would have been in '22, I believe you know what, I have it here.
Also in 22, I was just trying.
Yeah, we filed the final order on October 5, 2022. So the court had it for a little bit more than a year. We did not do oral argument on that.
Comments? No more? Thank you very much, Steve.
Thank you, Mr. Chair.
Moving on to item 12C, legislative report. Carrie, you're back on.
Thank you, Mr. Chair. The 2025 legislative session is now underway. We do have a couple things that are moving and some other things that have been filed. Just to update you, because as you know, a lot of things happened since I sent the legislative report to you a couple weeks ago. Senate Bill 348, filed by Senator Gates with a House companion bill of House Bill 399, filed by Maney. In the Senate, this bill is moving. It is the Stolen Valor Bill that also contains the Commission's recommendation with regard to salary withholding for civil penalties and complaints. This bill would increase the Commission's jurisdiction, making it a violation of the Ethics Code for candidates, elected public officers, appointed public officers, and public employees to knowingly misrepresent their armed forces service records, awards, or qualifications, or wearing any uniform, medal, or insignia that they are not authorized to wear. It would also permit the Commission advocates to utilize salary withholding for unpaid civil penalties from complaints when the respondent is a public employee or a public official. We have had 2 committee meetings on that bill. It's had a very strong reception in the Senate so far. It's not yet been scheduled in the House. Your whistleblower legislation was also filed by Senator Gates. That's Senate Bill 352. We have a House companion filed by Representative Benaroch, House Bill 495. Those have been assigned to committees but have not yet been heard. There is another bill that mainly, it's in the Senate, Senate Bill 7002. It's a committee bill by the Committee on Environment and Natural Resources, and it largely concerns things related to water management districts and their requirements. However, it does contain a provision that would apply the expenditure ban to water management district board members, executive directors, and certain others, and it would authorize the Commission to investigate any allegations of the violation of that expenditure ban. So we're monitoring that. There have been 3 bills proposed relating to political advertising and ballot initiatives that haven't been referred, that have been filed by members. We also have a bill filed in the House and the Senate that creates a new section of the Ethics Code prohibiting certain persons from knowingly and intentionally disclosing certain information or work product unless authorized to disclose such information by the chief executive officer of the legislative body or public employee or public employer, and creates a requirement for persons who receive such information or work product to refer that person to the Ethics Commission. We're just starting to dive into that one relating to labor relations, so we will be working on those and working with Commissioner Lucas, our designated legislative liaison, as we work through those and as issues arise. And that completes my legislative report. Unless there are questions, I'm happy to move on.
Any questions or comments?
If you would like to.
Commissioner Lucas was voluntold, I think that was, right? Is that what they call it?
Yes.
Yeah, let's move on to then, going to be reports, the last report, which is the e-filing report, item 12D. I'm sorry, yeah, it's D, sorry.
Thank you, Mr. Chair. E-filing to sort of catch on to the end of the RFP, in addition to getting ready to handle the RFP contract award. Commission staff is actively testing the electronic financial disclosure management system, or EFDMS for short. We are testing the fines aspect of the system, the rollout of which we expect to take place in April now. This will be the automation of the $25 a day fines into the new system, and that's for the annual failure when individuals fail to file timely their Form 1 and Form 6. It's the last piece of the e-filing puzzle. It will then make the fine assessment, payment, appeal, and collection process more efficient. It will happen in real time with the ability of late filers to pay a fine almost immediately after they file a late report, and they'll be able to file or pay their fine from within the system without having to go to a different platform to make that payment. In addition to fines testing, we're preparing for the upcoming filing season. We have coordinators finalizing their 2024 filer list. We're making commission updates to the email templates that go out, the forms, the instructions, the FAQ information for filers. We anticipate filer notifications to be emailed mid-May, and we're thrilled. It's not a big election year. We hope that we will see many return Form 1 filers very comfortable in the EFDMS system this year. We expect that later in 2025, this system will go from being actively built to more of a maintenance system where we'll hopefully get some items on our wish list or backlog checked off as it goes into that type of status. So next time we meet, we'll be further along in that process, both for the fines and for our Gear Up for disclosure season. And that completes my report.
Thank you very much. And you know it's bad when the initials are actually longer than the word itself. But, all right, any comments? We're going to take a quick 10-minute break. I know Ms. Hadley is back. We're going to be resuming with item consideration of final action joint stipulations 5B, as in boy. When we come back, we'll resume that. All right, take a 10-minute break. Thank you. Order, if I can get a roll call, please. Keep banging.
Here.
Here. Here.
Here.
Here.
Thank you very much. And we're going to be picking up on item 5B. And it's going to be stipulation for consideration is in complaint number 22-103, in re Michael Andrew White. Will the parties or their counsel please identify themselves for the record? Complainants have the right to respond in writing to proposed stipulations. The complainant's response in this stipulation was included in the supplemental mail-out materials. Are there any members of the commission who need to make a disclosure regarding this case? Seeing none, Ms. Hadley, you are now recognized to present the stipulation.
Respondent served as mayor of the town of Inglis. The commission found probable cause to believe he violated Section 112.3137 Florida statutes. Through settlement discussions, the parties have come to an agreement. In the stipulation, the respondent admits that he violated the Code of Ethics and agrees to the entry of a final order recommending a civil penalty of $500. I also read the response from the complainant, who is not a party to the case, and I recognize she wants a higher fine. However, it appears that the items in her response are concerned with the respondent as the current owner of the property that originally caused the conflict. This stipulation is to resolve the conflict from the original matter, the 112.3137 matter, and we respectfully ask for the commission's approval of the joint stipulation.
Any questions from the members?
Yes, I just wanted to ask, what was the underlying violation here?
It was a conflicting contractual relationship. What happened is that the respondent was the mayor, and there was some property that he had previously owned that was then, I'm trying to use the right word, it then became owned by the city, the town of Inglis. At some point, there were some issues with the property, so the town, not the respondent, town council members voted to sell him the property back for $10. So the conflict was regarding the matter with him purchasing the property from the town and the issues that came along with the contract, not purchasing, not paying for it, it still belonged to the town, issues were coming up. So that's where the underlying conflict relationship occurred.
Was there a financial disclosure issue related to this as well?
If it was dismissed. Let me look. Because no, it appears that the original issues were a disproportionate benefit, abuse of position issue, the constitutional matter, 112 through 136, which is a misuse, and this 7. The 7 is the only item that survived.
It just struck me as I'm reading through today's session, how the maximum fine that we can issue for financial disclosure is $1,500. And through the succession, is that right? Through the succession of days, it's capped out at $1,500? And that this was a $500. Go ahead.
So there's two different ways that we assess fines or penalties. The automatic fines for a late financial disclosure are $25 a day up to 60 days, which is a cap of $1,500. But for penalties assessed by you through final action for ethics complaints or referrals, the maximum civil penalty for any one violation is $20,000
At this time.
at this time. There was a statutory change last year or the year before to up it from $10,000 to $20,000.
So it kind of begs the question, how did we get to $500 here?
So when looking at so I look at the facts of the case. In this particular case, while there is a 7, and I do stand strong that there was a 7 violation, it wasn't a terribly manipulative action that occurred. The respondent wasn't involved with requesting that the town sell him the property. Those were town council members who asked for that. It was just the fact that he was the mayor at the time that caused conflict with the town. So he didn't take any particular actions that caused him to be in violation, other than the fact that he did enter into a contractual relationship. So it's just the facts of this particular case.
So because he didn't initiate the process, you're saying?
That's a portion of it.
Yeah.
And also, while we did initially try to go to DOA on this matter, we were continuously trying to work on the stipulation as well. So that goes into factor into that amount as well.
So it goes without saying that you believe that this settlement is in the best interest of the state, correct?
Yes, sir, for this case, yes, sir.
Thank you. Any further? Oh,
I just had a question, a follow-up. There was not a requirement for, at the time of the vote, he was mayor as a possible conflict?
I'm sorry, repeat it one more
When
time.
the purchase agreement was, I guess, requested to be dissolved, or however they went about it, for the property.
So tell me if I'm answering your question correctly. So that's why we're here, because when looking at that there was a contractual agreement between his agency, which is the town, and he was the mayor, that's where I made the recommendation that there was a conflicting contractual relationship.
Okay, so you did declare it was a conflict.
Yes, sir, and that's what he's admitted to. Yes, ma'am, that's what he's admitted to as a 7 violation.
any further comments? Can I get a motion to accept?
Move to approve.
Second?
Second.
Okay. Any opposition? All in favor, say yes. Yes. Right. Motion passes unanimously. Item C. I'm sorry, it's been continued, I apologize. We're off to E. And that's going to be, this consideration of the stipulation in complaint number 24-156, In re Bowen Coop. The complainant in this matter did not file a response to the stipulation. Will the parties, excuse me, will the parties or their counsels please identify themselves for the court, for the record? Nobody's present. Are there any members of the commission who need to make a disclosure regarding this case? If so, please state it and for the record. No disclosures. Ms. Hadley, you're recognized to present the stipulation.
Respondent was a candidate for the Florida State Senate. The commission found probable cause to believe he violated Article 2, Section 8 Florida Constitution and Section 112.3144 of the Florida statutes regarding his 2023 CE Form 6. Through settlement discussions, the parties have come to an agreement, and the respondent admits that he violated the Code of Ethics and agrees to the entry of an order recommending a civil penalty of $1,500 in public censure and reprimand. To clarify how I got to it, there are 3 matters that occurred in the form. My typical, when it's a typical case, is $500 per matter. So there were 3 issues that occurred in his form. So that's where the $1,500 came about. We respectfully ask for the commission's approval of the joint stipulation.
Anybody have any questions? Comments? Okay.
Oh, excuse me.
Yes.
Okay. And I misspoke, it's only a $1,500 fine, not public censure and reprimand.
All right, can I get a motion to accept, reject, or table?
Move to approve?
Approve, we got what? Got a second? All in favor, say yes.
Yes.
Okay.
Yes.
Passes, thank you very much. We're off to F. Item 5F, consideration of final action, joint stipulation. This is a consideration of stipulation in complaint number 24-172 and 24-225. They're consolidated. In re Lauro Diaz. The complainant in this matter did not file any responses to the stipulation in this case. Will the parties or their counsel please identify themselves for the record? Thank you. Are there any members of the commission who need to make a disclosure regarding this case? Thank you. Ms. Hadley, you're now recognized to present the stipulation.
Respondent was a candidate for Palm Beach County Sheriff. The commission found probable cause to believe respondent violated Article 2, Section 8 Florida Constitution and Section 112.3144 of the Florida statutes regarding his 2023 CE Form 6. Through settlement discussions, the parties have come to an agreement. Respondent admits he violated the Code of Ethics and agrees to the entry of a final order recommending a penalty of $500. In this particular case, there was one matter in which he did not do his form correctly. We respectfully ask for the commission's approval of the joint stipulation.
Any questions? Can I have a motion to accept, reject, or table?
Move to approve?
Second, thank you. All in favor, say yes.
Yes.
Motion passes. Item 6, consideration of advocate's motion to dismiss complaint.
Good morning, Joseph Burns, advocate for the commission.
All right, this matter is in consideration of the advocate's motion to dismiss complaint number 19-131 in re James Cooey. If the commission grants the advocate's motion, the matter would be dismissed. Alternatively, if the commission were to deny the motion, the case would proceed to the Division of Administrative Hearings for an evidentiary hearing, or the parties could reach a settlement agreement. Are there any members who need to make a disclosure? Will the parties or their counsels on this case please identify themselves for the record? Mr. Burns, you are now recognized to present your motion.
Thank you, Chair. First, I'd like to note that the advocate's recommendation and a first draft of this motion to dismiss were drafted by former advocate Elizabeth Miller based on a mistake of fact that she later discovered. Respondent served on the Bayshore Gardens Park and Recreation District Board of Trustees and is alleged to have violated Section 112.3133 Florida statutes by acting in his official capacity to do business with a business entity that was owned by his wife. In December of 2017, respondent's wife was hired as an employee of the district by the district manager, who had authority to hire and fire employees without the board's approval. In April of 2018, the district manager executed a contract with Cooey Consultants LLC, which was a business entity owned by respondent's wife, for the wife's provision of hall monitor services for the district. The previous advocate specified that the board did not ratify this contract. The previous advocate, understanding that entering into contracts required board approval, imputed responsibility for the contract to the board, including the respondent. But because a violation of section 112.3133 requires some action by the respondent in order to form a violation, and the evidence is uncontroverted that respondent did not take any action to form a contract with his wife's company, the complaint should be dismissed. That's my presentation. I'm available for questions.
Thank you. Any questions? Can I get a motion to accept or deny the motion?
Move to approve.
Get a second?
Second.
All in favor, say yes.
Yes.
Yes, thank you. Thank you, Mr. Burns. We're going to move on now, bouncing around back. We're going to move on to item 10. I believe everything else has been covered. Okay, item 10. Okay, we have a member who has requested to attend commission's meetings remotely. And although the commission has held a few public session meetings where everyone attended via teleconference, we have not had meetings where some members attend in person while others attend remotely. As this concerns how the commission conducts its meetings, staff has researched remote and hybrid meetings, and I had the executive director put this on the agenda for discussion today to at least touch upon it today. Carrie?
Thank you, Mr. Chair. A commission member has inquired about the ability for the commission to hold meetings remotely or for some members to attend remote. However, due to confidentiality of complaints, fully remote executive session meetings are not possible. And so we have been looking at hybrid meetings where members could attend remotely while staff and parties for proceedings and some members would be in person. There are legal requirements for meetings, and staff has researched the legal requirements as well as the logistical considerations for these options, and I'm going to ask Steve to talk about kind of the legal considerations that we have to look at before I talk about the logistics of it, before your discussion.
Thank you. Thank you, Mr. Chair. There are two ways that you can hold a meeting, of course. There are in-person meetings, and then there are rules promulgated by the Administration Commission where you can hold meetings by what's called communications media technology. So that would be what we would call a remote meeting, where you would basically have that over a video conference or over a teleconference. For in-person meetings, in order to gavel in, you must have a physical quorum present at the physical location that is noticed for the meeting. The meeting must be noticed for a physical location. It must be noticed such that the public can attend. And there are several Attorney General opinions about this quorum requirement and how it will work if a member is to appear remotely. First of all, there are Attorney General opinions that do allow commissioners to attend a physical meeting remotely in the case of some sort of medical issue. They don't use the phrase reasonable accommodation, but essentially an issue that would, it seems to be that that's what they're spelling out in the AGO opinions, is some sort of physical or medical incapability to attend a particular meeting due to some sort of sudden or medical occurrence. In those instances, that person can attend a physical meeting remotely, but anybody who does not attend, if they are not in physical presence at the meeting, then they do not count towards the quorum, though they may vote, according to the Attorney General opinions. There's at least one other opinion that discusses whether or not board members can attend a physical meeting by remote means for reasons of something like a schedule conflict. And the AGO opinion on that seems to indicate that that is a matter for the collegial body to decide how it wants to hold its meetings and what it wants its meetings to look like and how it wants its members to attend or not attend those meetings. But again, anyone who attends a physical meeting remotely will not count towards the quorum. CMT meetings, or communications media technology meetings, they work slightly differently. They are noticed to happen in a video conference or in a teleconference. The commission would be obligated to provide access points to allow the public to attend. Those access points would be mentioned in the notice itself. But then all commission members would be able to attend those meetings remotely. The parties would also be able to attend remotely. Everybody would be remote. Again, as the executive director will go into, when everyone is remote, including the parties, whether or not we are maintaining confidentiality in the executive session because a complainant who is allowed to attend the various meetings, there's no telling who will be in the room with them, whether it be another person or a member of the press or whomever. So for that reason, we've never done executive session meetings by CMT, Communications Media Technology. So those are the rules. For in-person meetings, you must notice the meeting for a physical place. You can have some members attend remotely, potentially, for medical reasons. If it's for some other reason, then the collegial body, as a body, must decide whether or not it wants to do something like that. Anybody who does attend a physical meeting by remote means will not count towards the quorum, but they may vote. I'm available for any questions on the legal side of this, but again, Carrie Stillman will be handling the practical and logistical and cost side of this.
Any questions? Yes, go ahead, Commissioner.
So if they attend remotely, their vote would not count, they would not count toward the quorum. What about their vote? Would the vote be counted?
The vote will be counted. They are allowed to vote according to the Attorney General opinions.
Any further comments or questions?
I guess procedurally, were you going to make any further presentation on the practical side, or are we just open for discussion right now?
I do have a few things to make you all aware of, but this conversation can go how you want it to go. I can talk about that after you all discuss.
But you can start now if you want, and then we'll go with Carrie after. Or do you want? All right, Steve, thanks a lot. Appreciate it.
Thank you.
You're on.
Okay. Thank you again. So Steve's given you the lay of the land of the legal aspects. Logistically, he also explained the challenge that lies with closed session meetings that we have, which is why we can't really do fully remote, which is why the commissioner asked us to look at the possibility of some members attending remotely. We don't have our own dedicated meeting space, meaning we can't outfit a room with fixed technology that would belong to us. This is the court's property. So we worked with the court IT staff who've been really helpful to us. We have run tests in this meeting room as to how we would do it, whether or not we could do it if you all decided that you wanted to have hybrid meetings in this space. The technology would be like a Zoom meeting platform with a laptop with a microphone to it, and we would be able to do it in this room. It might not be easy for someone to hear. We did a mock meeting with staff, people calling in, people attending by Zoom. We were able to make it work. It is less than ideal because there is risk if the technology fails in terms of the Zoom, but we can make it work here if that is your decision. We also looked at Senate meeting rooms. We worked with Senate IT staff to do a mock commission meeting prior to session being in place. They do have a couple of meeting locations at the Senate that are outfitted where for public session there would be video boards where you could see the commissioner or commissioners who were not in attendance. So during public session, they would be wired through a Zoom meeting that would work through the Florida channel, which would also be broadcasting our meetings, which is not required, but I think is an important component to transparency so the public can view what the commission is doing, and that is a pretty smooth operation down at the Senate because they've made that investment in technology. The executive session is a little bit trickier because we'd likely be operating off of conference call technology in that room, so sound might be a little more dicey. The other consideration with meeting at the Senate, or if the House would allow us to utilize their space as well, is of course, we're not going to be able to meet there during session, or potentially during committee weeks. They can't always guarantee our access to the room because obviously, we'll get bumped. In the past, we have met at the Senate or at the House at various times, and we would get bumped, and that started to be a bit of a challenge. But we do have those options. If ultimately you go with a hybrid option, and it is something that the commission wishes to do going forward, there are some things we can do to improve the meeting experience. It would involve an investment of dollars into some technology that would be portable. One would be, for example, a Surface Hub 3 that brings the best of Microsoft Teams to this meeting room. It would host calls, video, mics. There'd be a television where people would be able to see members, but the setup would run, according to our IT staff, around $20,000. The $10,000 of that is in the special TV or video board that would be utilized. The other option would potentially be iPads connected to a sound mixer. We'd need to purchase those iPads and also a new soundboard because we're maxed out on our existing board, and that's likely going to run a little bit less, with the iPads approximately $1,000 each and the soundboard around $2,000. And so we await what you would like to do, and then staff will work diligently to provide the best possible environment should you decide to move forward with the hybrid meeting. I will note that Commissioner Lyle, who is not here, is somebody who is the person who brought this to us, brought this to staff, and I know it's an important matter to him, and that he wishes he could be here today to be a part of this consideration.
Right, and although he's not here, I did want to have the discussion anyways, but by no means want to end it today. So it's something that's going to be moved around a lot, hopefully flush it out. Commissioner Lucas, did you have a?
Yeah, and it might be premature if all we're doing is discussing, but my opinion on this probably carries very little weight because I live 15 minutes away from this building. And Tallahassee is extremely difficult to get to. Commissioner Bain had a flight canceled. Commissioner Bush drove 8 hours. It's not easy to get here. But it's also not easy for respondents to get here, and they don't have a choice. We do have a choice. And so as long as we have folks who are forced to come here involuntarily and have to appear in person, it strikes me as inequitable and frankly really bad optics if we granted ourselves the luxury of attending remotely when the same courtesy is not granted to respondents. And I'm off my soapbox now.
Commissioner Bush?
Well, is this inevitable? If this is where we're moving toward the hybrid meetings, this is what is going to take place regardless?
No, one of the commissioners brought it to the director's attention, and that's what we're having a discussion. There's no inevitableness unless we move it in that way. It's up to us, the body, to decide whether, we're going to entertain that or not. Today's discussion is just to toss it around and discuss it.
So what would be the main reason? I know in your report you indicated that for members who might be for medical reasons, but what would be the main reason why we should move toward this end?
I can't answer that question. To me, I'm on the same position as Commissioner Lucas, although I live probably the furthest from anybody up here, and I practice law and I believe in the advent of remote hearings, but for this matter, for this case, the delicacy and what we're dealing with here and the fact that people have to come here, And it may be a old school mentality, but just from the optics of it, you know, my position is, even though it's an inconvenience for me to fly up here, my position is firm on keeping it the way it is. That's just, and again, it may be premature, but notwithstanding the logistics, notwithstanding the cost, I have an issue with the security concerns, obviously. But regardless, if the respondents have to come here, then I see that as really a sign of respect to the people that were, you know, making decisions over their lives to be here for them. That's just my position on that. So it's not inevitable. It's up to us.
Yes.
I agree.
Any comments, questions?
I agree with everything that's been said. I agree with the position Ms. Lucas stated very, very clearly. My only comment or suggestion would be maybe look at making more use of the work that goes into setting this up and making these sessions take a full day, rather than, and cutting down maybe on the frequency of, rather than having 8 or 10 meetings a year, maybe have 6 or 4, but just have them last longer. Because logistically, cost-wise, there's so much that's spent for us to be here today. You know, if we can make better use of that time and have a fuller day, it doesn't end at 1 o'clock, maybe it ends at 5 o'clock. You know, I'm all in favor of that. So maybe there are other things that we can look at to make more full use of the time that we set aside for this day. Another alternative would be, you know, for the sessions that are purely public, like the opening session that we have today, those might be allowed to be remote, but the ones that have to go into executive session, those clearly would have to be in person. So those are just some other options to look at, maybe how we shake up, how we hold these meetings. So,
Through the chair, as we consider those types of things, when you're in your discussions, there are 2 things that come to mind for me about that on the legal side of things. One is, and we haven't had one of these yet, but normally we have a lot of these where we get recommended orders back from the ALJ. I described earlier a case where we had a recommended order come back from an ALJ, and we have a final hearing to become a final order. The Administrative Procedure Act requires us to turn a recommended order into a final order within 90 days of issuance. And our meetings are every 6 to 7 weeks, which is every 42 to 47 days. And that's done strategically, because if we get a recommended order, like let's say a week or 2 before a mail out, which is not enough time for us to really turn that into a final order, get all the exceptions, there's a time period to get exceptions to that final order. So we could be bumping up against, if we spread that out or attenuate that time, we could be bumping up against the 90 days in other respects. So there's a concern there that we would have to manage and really do some hard math on. That's number one. Number two, other thing that we need to think about is this particular composition of the commission has been pretty quick in making its decisions, and I think people that have been here for, particularly staff, there are other compositions of the commission that are much more back and forth, a lot more questions for parties, and it becomes, you know, it only takes a few commissioners who have a different perspective on how deep they want to get to really throw things in a different direction here. And so that's something else to be thinking about.
You want me to run the meetings till 5 o'clock? Is that what you're telling me?
It's your prerogative to do it.
No, I'm just kidding. No, I understand that, and it's true. But the Commissioner Bain, the recommendations you make, it's smart. Instead of piling it into 2 days, but then again, you got the consideration of the 90 days. So some logistics, you're going to have to, I say logistically, you have to figure it out if that's even possible. Any other comments? I guess we'll table this until we have a full commission.
Mr. Chair, excuse me,
Oh.
I'm sorry, we do have a member of the public who would like to comment.
Oh,
Okay.
okay.
Mr. Chairman, members of the commission, Mark Herron, member of the public, as well as somebody that appears here occasionally. I would urge the commission to keep its current meeting format. And one of the reasons I think you need to do that is it keeps the quality of our interaction from here to you more personal. I can see if a member of the commission is getting my argument or not getting my argument. I can try to refine that argument to get to that commissioner's understanding of my argument. It also, I think, allows you to understand each other better than being on a Zoom or a other kind of video platform. That's kind of my only 2 cents about this. Again, I'm an old timer. I was here. I'm probably the oldest guy in the room, I'm sure. But I think it's important that this commission keep its deliberations like it does. As the chairman said, or somebody said, it shows respect when people come before you, rather than sitting in their living room or their bedroom with their fan going around. It shows respect that they have respect for this commission. So again, that's my 2 cents on this. I understand it's not a closed argument. You may consider it illegal, but that's my 2 cents today. Thank you.
Thank you very much. Any further discussion? No? All right.
I just wanted to make a comment, too. I agree with the majority of comments made here, but also I think that the illness or might be something that we could consider a call-in for the open session, but not the executive session. So I would like to make sure we don't dissolve that idea. I just had a hip operation, so I'm a little bit sensitive to having come here when it wouldn't be that easy.
Thank you for that, by the way. Yes. Terry.
Mr. Chair, we appreciate the conversation here today and the suggestions that have been made. Your staff always takes it seriously when a member has an idea or a concern. And so we will get busy, researching and working to be creative, so that we can do whatever we need to do in relation to how the commission would like to conduct its meetings.
This time, I'd get a motion to adjourn the public session.
So move.
Second?
Second.
All in favor, say aye. Aye. We're adjourned.